Well, welcome to today's episode of the Children First Family Law Podcast. I am really excited to introduce everyone to the Honorable Retired Federal Magistrate Judge, Michael Hegarty, and he is a friend and colleague and someone for whom I clerked. He gave me the amazing opportunity to clerk when I guess I interned with you when I was an old lady in law school, and he gave me a chance to come and work with him. And then I got to clerk for him when I graduated. And so he just retired and is now mediating full time. So I am really excited that he's here to talk with me about his career journey and also to help us all understand how keeping solutions in your own hands is better than taking it to court almost always. So welcome.
Thank you, Krista. Good to be here.
Yeah, so let's just start. Let's give a little history of how you got onto the bench and how you got to where you are now. So
Sure.
I know that was a long time ago, but give us a little journey through time of how you got into U.S. Attorney's Office and all those good things.
Okay. Well, so I was studying political science and economics in undergrad, went to Europe for a year to study, didn't know what I was going to do when I got back, had done well in undergrad. And I thought, man, I don't, how can you get a job in political science and economics? So from Europe, I applied to law school, came back, assumed that if I got B's and C's, I'd be able to at least get a job after I graduated. And lo and behold, it went better than that. And did well in law school. But I believed at the time, and I still believe it, that the best thing that a law graduate can do is clerk or a judge. And I fell in love with the federal court. So I clerked for a U.S. district judge in Kansas for 2 years. And then followed a colleague out to Washington, D.C. To work for Arnold and Porter in D.C. In fact, I worked with Mary Darling, the immediate preceding U.S. Attorney General.
Well, and for most listeners may not know Arnold and Porter either is like a huge international big dog law firm. So very competitive, lots and lots of high level cases.
Right. Yes. And one of the best in the country. Had an opportunity out there to come to the Denver office of Arnold and Porter and was starting to have more children. We had our third out in DC, and I didn't think that was going to stop, and it didn't for a long time. So we moved to Denver to be in the Denver office of Arnold and Porter. And, I just felt that the big firm life wasn't my calling. The things they do are good, but mostly they represent, business interests in various ways. And I wanted to provide more meaning to my life than that. So as fortune would have it, or destiny, I got to know the U.S. attorney named Mike Norton at the time. And he hired me at the U.S. Attorney's Office, August 1992.
So now though you're now working for JAMS, is that right?
Yes, James.
And so tell us a little bit about that. So that's one of the two, I think, big a lot of former judges go and get these wonderful still ability to help do mediation essentially.
Right.
What kind of cases did you jump right into that right after retirement?
I had 2 weeks.
Okay,
Probably
2 weeks,
enough
right.
time. Yeah. So when I was a magistrate judge in the federal court, one of our collateral duties would be to hold settlement conferences. That's what we call them, which you participated in dozens, if not 100 with me. And so I did 1,400 of those in the U.S. Attorney's Office, the U.S. District Court. That means two parties to a lawsuit. They could end up going to trial, but if you want to keep your destiny in your own hands, you go to a mediation, a settlement conference in federal courts, a mediation with a private person, and you try to control your own destiny. You try to work out an arrangement you can live with, both sides can live with. So I did that so often, it was sort of a natural thing to do after I retired from the bench. And I was pretty successful at it, you know that. So I'm doing a lot of the same things. In fact, I'd say maybe 2/3 of the cases I'm doing are federal cases. In fact, I had one the other day that was my case, my consent case.
Oh, wow.
I had issued an order on summary judgment limiting a party's damages. It had not yet gone to trial. I left the bench. It was assigned to the new magistrate judge who took my spot, and then they selected me to try to resolve the case. And that was interesting because
That's
I
interesting.
opened up the file. I saw the case name. I said, I know this case. I walked into the plaintiff's room and I had ordered, I had ruled against them. And I said, you do realize I'm the same person who ruled against you in the federal court.
Right.
And they
Interesting
said, yeah.
choice. I remember some of the cases you and I had the privilege of working alongside you on. Like, I remember the big one was the civil Aurora movie, the civil side of the Aurora
Were you
Batman.
there for that? Were you there when those guys came in one at a time? Were you with me?
Yeah, yeah.
And
So it was
and
the
they rolled up
civil
their
side.
sleeves. They rolled up their pant legs. They wanted to show me their wounds.
Yeah, so this for the audience's sake, just it's so with the Batman massacre shooting at the Aurora movie theater, there of course was the criminal side, but then there was that was the suit against the theater, basically. I mean, that was one of no, sorry. There was a criminal side of it, but then there was also the civil suit that we had, which was against the movie theater. Or the other one was against obviously the person, the perpetrator. But the civil suit that we had was a bunch of different plaintiffs' attorneys with a bunch of different plaintiffs. I don't remember how many there were. Do you? I mean,
Well, so James Holmes was tried and convicted in Colorado State
right.
Court in
Yep.
Denver
Yep.
and actually, sentenced to life. Then the people who were injured or killed, their heirs, brought two lawsuits. One was in state court
Mm.
and one was in federal court against Cinemark, claiming that the breakdown in security, that they'd had warning that something could happen. That was their theory. Okay. So half the plaintiffs were in state court, half were in our court. And the plaintiffs in the state court, they got their case thrown out. It was dismissed because they didn't have a claim against Cinemark. The court just
And
said,
it
well,
was things like the door was propped open,
yeah, for
things like
brief
that.
time,
Yeah.
right.
That's
And
the principle.
so the other plaintiffs were in our court, and there were 50, I think. I think
Yeah, I think
100
that
total
sounds right.
people. But they wanted to be heard. This was their only day in court, and they wanted to show us their wounds. They wanted to talk to us. You remember the stories that
Yeah.
he said we were in the fifth row. He was going row by row. We were just waiting for our turn to be killed.
I mean, we had people pull their legs up, and I mean, just to describe this to people because it just was so powerful. I mean, I remember we started with a lot of them like in the jury box, and I mean, this is just we were just using the courtroom as a room. It wasn't a court hearing or anything like that. And we were moving around between all these different plaintiffs' attorneys. I think we had all the plaintiffs' attorneys in one room in the big conference room. There were I don't know 20 plaintiffs' attorneys, and all the plaintiffs were in the courtroom. And you're navigating between that, and you got the Cinemark people,
Like, don't
they're
you remember they came back to chambers?
yeah,
So
and then
this
we
is what
brought
they
them
have.
back so they could tell their stories because it was clear that they had the risk of not going further, and this might be their day in court,
Right.
right? And they wanted to be heard, and they wanted to have empathy, which I think is just interesting
Yeah.
relationally. What are your thoughts on the obligation of attorneys to, both advocate for their client, but also be advocating for justice, advocating for families in my case.
So I guess the major problem I see is they try to insert themselves between me and the client. They can see maybe their client being interested in something, but it's not what they want, maybe because it is not enough for their bottom line. And then they steer their client away. And sometimes I just speak directly to the lawyer. I said, listen, this is their case. You're the attorney on the case, yes, but it's their decision. They get to make it as long as they make it with informed consent, full knowledge. And I'm trying to give them that full knowledge. And I even say sometimes, why are you being so aggressive? Why are you being so negative? You know, and it's not like they have to because my mediations, everybody's in different rooms. So
Right.
it's not like they have to show off like a peacock to the other side that's strutting their stuff. And they're not going to impress me in any
Right.
way. What
Right.
impresses me is that quiet uh, determination, assertiveness, knowledge, wisdom. That's usually the silent ones who are listening, who I would be most concerned about if I was the other side. They're taking in everything and they're determining how to respond wisely, professionally, and powerfully. Whereas the people who just want to boast and promote their position all the time, I would love to try a case against that kind of lawyer, because they will say something that will ruin their case because they just go off at their mind. But what the lawyer's obligation to do is to, at the bottom line, get their client the best resolution they can under the law, fairly, within the bounds of ethics. That's it in a nutshell. And, I don't think all of them see it that way, as you just said.